Hi, and welcome. I'm James Cooper, a professor of law here at Antonin Scalia Law School and the director of the program on economics and privacy, division of the Law and Economics Center. The mission of the program on economics and privacy is to foster sound economic analysis of privacy and data security, as well as other pressing competition and consumer protection issues facing the digital economy. We do this by supporting original research, educational programs, and public policy programs like the one we have today. I'm pleased to have with me today Maneesha Mithal and Andrew Stivers for really, I believe this is the third year in a row we've done this. So it's fantastic to have both of you back to talk about kind of assess the first year of the new administration in terms of privacy and take some predictions about what's going to happen in the future. So you can look up their full bios in the online content or the online information for this program. But Benisha's a partner at Wilson Sonsini. She's the co-chair of the firm's privacy and data security practice. Before that, and where I got to know Maneesha was when she was at the FTC, and she was the head of DPIP, the Division of Privacy and Identity Protection, where she was instrumental in sort of guiding the FTC's policy in application of Section 5 and other tools toward privacy and data security issues. Andrew Stivers is a managing director at NERA, National Economic Research Associates. Andrew is an economist specializing in consumer protection and privacy issues. Again, I got to know Andrew at the FTC as well, where he served as the deputy director for consumer protection in the Bureau of Economics, not to be confused with the deputy director for economics in the Bureau of Consumer Protection, a position that I once held. We complete each other if you put us together. Andrew, again, is an expert in the economics of privacy. So we are thrilled to have both of you here for again our third conversation. I promise not to pull up predictions you may have made from last year and test them against what really happened. But I do want to get started with a question. Looking back, how would you evaluate this first year of, the Trump 2 FTC, the Andrew Ferguson FTC? Where do you see continuity with the prior FTC and the prior administration? And where do you see change? I mean, we had certainly while now Chair Ferguson was a commissioner, there was some strenuous dissent. Seemed to be like a lot of disagreement with a lot of what the Lena Khan FTC was doing. But now that we're a year on, how much of how much is different, how much has changed? So Maneesha, I want to turn to you first, and then I'll let Andrew add in as well.
Great. Thanks for that introduction, James. I do think that there are some areas of strong continuity between this administration and the last. So I'll just mention a couple of them. The first is kids and teens, minor safety. I think that's a perennial issue. This administration has signaled a strong willingness to enforce the Children's Online Privacy Protection Act, as we saw from the Disney case last year, a couple of other COPPA cases last year that were announced under this administration. And they recently had this workshop on age assurance technologies and age verification. And so I'm sure we'll be seeing more along those lines. So I think this is going to be a big issue for this administration, as it was for the last. A second area where I think we're seeing strong continuity is in the enforcement of the laws against subscription services and renewal and click to cancel. So again, this administration announced the $2.5 billion settlement with Amazon, large civil penalty settlements with companies like Instacart. And so I think we're going to continue to see enforcement of the laws called ROSCA, Restore Online Shoppers Confidence Act. And I think this commission, like the last one, is going to be very heavily focused on that as kind of a pocketbook issue for consumers. And the last area I'll say kind of continuity, I think there is a a sense that a strong enforcement involving laws that Congress has passed and involving some of the rules that I think we often see kind of a Section 5 through line, but I think in this administration we're going to see a doubling down and a focus on the laws Congress passed. So the FTC sent warning letters on PADFA, the Protecting Americans' Data from Foreign Adversaries Act. This is a law that Congress passed. I think the FTC will scrutinize that. We've seen statements out of the FTC that they're going to be prioritizing the Take It Down Act, which is a law that addresses reporting and takedown of non-consensual intimate imagery. They did a sweep on fake reviews earlier this year. So I think those kinds of non-Section 5 sector-specific laws that Congress has enacted, that kind of enforcement is going to continue. And then kind of to your second point of your question, James, on areas of divergence, I think the most kind of public one is probably AI. The last administration was very focused on things like AI safety, concepts like algorithmic discrimination. And this administration, following the lead of initial executive orders that were issued by the Trump administration, has been a lot more hands off on AI. They've been bringing deception cases where companies have misrepresented the use of AI, but this idea of AI safety, algorithmic discrimination, I think that is certainly an area of divergence. I think we're also seeing some new areas that were not kind of priorities of the prior administration. There's things like content moderation, which Chairman Ferguson has really set his sights on, as he did an RFI last year on this issue of content moderation. I think there's some areas, there are culture war issues, gender affirming care. I think that's a priority of this administration. We just saw the American Academy of Pediatrics filed a petition to quash involving a gender affirming care matter. And I think that, I think there's a couple of areas, though, that I would say I would put under the category of surprises. I think all the things I've talked about, I think, we've expected. Couple of areas of surprises. I think there's a willingness to use rulemaking authority under Mag Moss. This was never used before Chair Khan. Chair Khan initiated a number of Mag Moss rulemakings. In this administration, we see reports that the FTC has issued an ANPR on the negative option rule that the Eighth Circuit struck down earlier, but the FTC looks like it's going to again issue a notice of proposed rulemaking on that issue. So I think the willingness to use Mag Moss rulemaking is a bit of a surprise. The other piece that, in my mind, is a little bit of a surprise is that typically we see Republican administrations come in and they tend to be more, I would say, business friendly in terms of burdens of civil investigative demands and investigations and things like that. And from what we've seen, that has not been the case in this administration. We've seen very long CIDs. We've seen a lot of, we've seen statements from Chris Mufarage saying that companies really need to cooperate with these long CIDs and really kind of develop production schedules. So not a lot of leniency on that front, I would say. So that's kind of one of the areas of surprises. So I'll stop there and curious what Andrew has to add to that.
Thanks, Maneesha. This is really enlightening. Before I get to Andrew, I just want to have one quick follow-up question with you, which was interesting. You mentioned the rulemaking. I wasn't aware of that, and I was aware of kind of the ROSCA on steroids or at least continuing on. How much of this, and I'm asking you this as again a former enforcer and also someone who advises clients now, how much of this do you think is a money issue for the FTC in the wake of AMG, as we all know, you don't have the ability to get money under 13B, and you saw obvious, but under rules you can. ROSCA, not a rule, but a statute that's enforced by Congress, and then of course with Mag Moss you can get money there as well for willful or negligent violations. The rule different pots. Do you think that's driving a lot of this?
I do, but I think what's interesting about the click to cancel They, as you point out, they already have ROSCA. They can
Yeah.
already get civil penalties under ROSCA. I think that I think it'll be curious to see, like in the ANPR, what is the impetus for this? Now, ROSCA only applies to online companies. We've seen that they've brought some cases against gyms and others, and so maybe that's the hole they're trying to fill. But I think it's very curious, and I think your question highlights, why they want to undertake this exercise.
Okay. Well, thanks, Maneesha. So, Andrew, let me turn to you. Any observations, again, from your vantage point, both as a former enforcer or economist at the FTC and in your current gig working with clients who might be in the FTC's crosshairs? I mean, what do you see as far as continuity and change in this administration?
Thanks, James. So I agree with Manisha. I think there's been a fair amount of continuity in terms of we're still seeing reasonably aggressive cases against a variety of firms in the areas that Manisha mentioned. I think to one of her last points, early on in the administration, Chairman Ferguson gave an interview. I think it was on MSNBC maybe, where he expressed the idea that, well, we're going to be empathetic to business because like we're Republicans, but also we're going to be pretty tough. Like we're not necessarily going to trust that they've got it right, or that they can just say, hey, no, we're business, we're okay. And I think that the experience that I've seen and that Manisha articulated is right, that I have seen some fairly aggressive CIDs and some very probing questions. So I really get the sense that they're not taking anything for granted, and they're really pursuing these issues, particularly in terms of sort of stuff that the ordinary Americans find annoying, cancellation fees, these kinds of things that I think are pain points, or at least express pain points by a lot of consumers. So I think that all is right. I will say that one of the things that this administration has leaned into on the consumer protection side is the economics and the importance of economic evidence in consumer protection cases. And I think we talked about this last year and talking about how previous administrations did take that into consideration. It often wasn't a front and center thing. And certainly from my perspective, I probably thought it wasn't given as much weight as perhaps I would have liked. But it was there. This administration has really vocally said, hey, we really think this is important. And my experience has been that it has been something that's been asked for. I will say that, just like with any case that I've seen, in some cases, I think we've gotten outcomes that were quite favorable based on the economics. In other cases, it made a difference, but perhaps I would have disagreed with the outcome, and so maybe it didn't have as much of an effect as I would have liked. So I think that fits with what Ferguson had said, is they are going to be pretty aggressive. They're going to listen, and I think for the most part that's been true.
Well, thanks, Andrew. I want to stick with you because I think it's a nice segue to a very related thing I wanted to ask you. You brought up economics, and do you think this administration is going to be more demanding with respect to injury in privacy cases? So, on one hand, as you mentioned, Chris Mufaraj, a graduate of this school and someone who's firmly steeped in economics, has kind of signaled that I think economics will be important in the Bureau of Consumer Protection. You have this upcoming a benefit cost or cost benefit workshop on information. I forget the exact title of it, reminiscent of the informational injury workshop that then Chairman Olhausen, acting Chairman Olhausen, put on back in, I guess, 2016 or 2017, I think. So you have that sort of signaling on one hand, and then on the other hand, I read, I follow, FTC settlements sometimes. I read stuff, and the GM OnStar settlement, it had to do with the, sort of driver tracking that is so ubiquitous in a lot of cars these days. And it include what was in there was some run-of-the-mill deception claim in it, but what I found sort of interesting, and again, this is settlement, but it's allegations in the complaint, unfairness related to locational tracking. And the harm was that it led to higher insurance rates because it detected less safe driving. And that was a harm. Like you could actually be charged. So, as an economist, I think of that maybe as markets operating more efficiently because it's getting rid of asymmetric information. But so it's kind of a little shock, but I wanted to kind of set this up to you and get your feel as someone who's really thought a lot about the economics of privacy and how we should think about harm. Your thoughts on where you kind of a continuation of what you just were talking about is where you think the administration might go in this.
Sure. So first of all, I'm going to be at the the injury workshop on the 26th, I think it is. I'm really looking forward to seeing that. And so everything I say, maybe they'll say something different there. So that should be really interesting. I think that there's certainly evidence that they're changing their approach. I mean, they seem not to be pursuing the so-called surveillance rule, surveillance capitalism rule, whatever they call it. So backing off on sort of this overarching, it's all full of injury, and we need to clamp down pretty heavily on privacy issues generally, and instead focusing more on teens and kids. But as you say, there's the OnStar settlement. I think the OnStar settlement is really interesting. So in general, this relates to a certain degree to personalized pricing, right? So the idea that rather than have some price of insurance or a coat at the department store specific to me, it's going to be, or everybody should just pay one price. And the idea is like, well, it's fair, it's anonymous. And often people worry that if it's personalized, they're going to get the short end of the stick. They're not necessarily thinking about the benefits. But if you think about insurance in particular, like my insurance rates are affected by drivers, in my demographic that are terrible. And so part of what I think would be efficient, and from an economic standpoint, is there a way to separate me and the risks that I bring to the table from somebody? Of course, every other driver is not as good as me, right? So there's other drivers that are more risky. And so from that perspective, you would think that people would say, oh, no, this is great. Like, look at my driving. And the reality is, I think, partly that everybody knows that, other people, but everybody else knows that they speed sometimes. Maybe they're not quite as attentive in their driving. They've got their phone out. And so they are worried that that kind of thing will be caught. The other side of that, though, is that one of the problems in privacy, if I'm being a little bit cheeky about it, is that the data isn't good enough, right? We're collecting a fair amount of data, but we're not collecting perfect data, and we don't necessarily link that data perfectly with behaviors. So, for example, a couple times a year, if I had a data recorder in my car, it would record me going 150 miles an hour. Every couple of minutes, it would record me slamming on the brakes, turning really sharply. If it's recording that data and then saying, oh, this guy's a terrible driver, maybe my rates go up. What's really going on is I'm on a racetrack, zipping around in a closed environment. But the problem is it's not clear how the insurance company is translating the data to greater risk. And that inaccuracy in that proxy can actually introduce quite an amount of inefficiency. And even if I think I'm a really good driver and I have a really good track record, it could be that the way that data is translated into higher rates affects me negatively. So, maybe I feel like I'm better off with that flat rate because I don't have to worry if the insurance company gets it wrong. So I think it is nuanced there. Typically for this kind of thing, I go back to what are the expectations of how that data is going to be used? What are the declarations? Is there sort of an effective way to implement consent? That kind of thing. But I have to say that, yeah, that case is potentially an indication that the kinds of privacy cases that we saw in previous administrations will be carried forward, at least to some degree, in this administration.
Thanks, Andrew, for that enlightening answer. Maneesha, just as a tiny bit of follow-up, I know we have a lot of ground to cover, but while we're on this, you as a perspective of someone who's, again, counseling clients all the time do you see, leaving aside the GM OnStar case, one of the areas that the prior administration was really aggressive, I think, was sort of defining and again, in this bucket of surveillance pricing, which I want to get into in a little more detail, but defining collecting data, browsing data for advertising, at least in some orders and some complaints, as unfair practice. I think of the BetterHelp that comes to mind, and I think there were a couple other consents in that vein. Have you noticed, or do you have a feeling if there'll be continuity there, or do you see the administration clawing back? Because I know that at least in the surveillance pricing rule, now Chairman Ferguson had a dissent, or not surveillance pricing rule, I'm sorry, in the report, but dissented a lot on that. So I'm just curious if you've seen anything, if you have any thoughts on that.
Yeah, I think what's interesting to me is that I feel like when you read the tea leaves of what Chairman Ferguson has said, I think there are some mixed messages on privacy. So, for example, there's the GM OnStar case that you mentioned. There's the 23andMe letter that they sent, essentially saying that they have to honor their choices and their privacy choices in the context of 23andMe. And then there were like some data broker cases that I thought those were interesting, that Ferguson voted for those cases, but dissented on one of the counts. And I think there's a common thread here. Similarly, the report you're talking about, there was a 6B report on social media and video streaming services that he concurred in part, dissented in part. And I think in that report, he said, targeted advertising is not harmful. I don't view targeted advertising as a harm. But if you look at another part of the report, he said his concern is not about the use of the data for targeted advertising. It's just the indiscriminate collection of data and the kind of dragnet of data collection. So I think it was a little bit of a mixed bag. Similarly, on the data broker cases, he concurred on the unfairness count that basically said you can't collect location data without opt-in consent. But he dissented on the count that said once you have the data, it kind of prohibited these sensitive categorizations. And so I think it's a little bit difficult to parse where he is on privacy. But that said, I can certainly say that privacy, other than children's privacy, general privacy seems to be a much lower priority for this administration generally. They abandoned the kind of commercial surveillance rulemaking. I don't think we've seen many privacy cases coming out of this administration that are not children's privacy cases. So I think it's a bit of a mixed bag in my mind on privacy.
Yeah. Well, thanks. I want to stick with you, Maneesha, and switch gears a little bit into AI, which I know is something that you do a lot of at Wilson Sonsini as well, and have thought a lot about. And it's something interesting. It's the writer case, which I found, at least I found interesting. So just as for those in the audience who are not familiar, there was a settlement with this AI drafting tool, writing tool. It was last year. I forget exactly when it was last year, but there were two main allegations. There was a means and instrumentality allegation that you're providing this AI tool, and somehow helping people write fake reviews. And then there was an unfairness claim that this tool in and of itself creates harm because it can be used to write fake reviews. And I know that at the time, Chairman Ferguson, then Commissioner Ferguson, and Commissioner Holyoke dissented pretty strongly on this. So that's just by way of background. Recently, in December, a little before the holidays last year, they voted to vacate this order. On the grounds that, one, there was never a Section 5 violation in the first place, and two, that the order which prohibits Writer from marketing or kind of putting its tool out there to be used for reviews anyway, would be they couldn't do that. So they said that wasn't in the public interest because it would discourage AI innovation. Now, I can I mean, to me, this is something that I haven't known to happen. The only time I can recall an order being set aside was actually on the competition side, and it was against a company, and it was because the Supreme Court had changed the standard with the Legion case on resale price maintenance. But I haven't seen anything like this, and I was wondering. I mean, here, you know, is there more to come? Vacating orders that against, I think of maybe the use of unfairness in a equal credit opportunity case, right? That was something where both Chairman Ferguson and Holyoke very much dissented. Number one, is this as weird as I think it is? And do you think there are potentially more to come, or do you just think this is because it's AI? So Maneesha, I'll leave it up to you to answer that long-winded question.
No, so I think I do think that the Ryder case is a special circumstance, partly because of what you mentioned. So shortly after this administration came in, there was an executive order from the Trump administration basically calling on federal agencies to re-examine orders from the last administration in particular regarding AI, and to rethink ongoing investigations on AI. And so I do think that this was kind of a special circumstance in that there was kind of, it was passed in the waning days of the last administration, or it was made public in the waning days of the last administration. And we had two kind of very clear dissents. It was involving AI. And so I don't know that this is going to, be kind of the tip of the iceberg in terms of like a number of orders being reopened. And I would contrast that with, like, say, there's another privacy case against kind of an app called SpyPhone, where there was like an order against the company as well as individuals, and the individuals filed a petition with the FTC to try to undo the order, and the FTC, kept the order and didn't reopen the order. Even though kind of I think the positions on individual liability may have changed during this administration. So there may be more cases. I am sure there are probably investigations that were ongoing and that started under the last administration that have been closed in this administration that we won't see public and that we won't know anything about. But in terms of like public orders that are being vacated, particularly in the absence of a petition, I don't see that as a widespread issue. Could there be one or two additional ones? Maybe, but I don't see it as a widespread area.
Okay. Well, thanks, Maneesha. Before I go on, I want to let everyone in the audience know that if you have a question, there is a Q&A box. I neglected to mention that in my introductory remarks. So if you have a question, throw it in there. I can't guarantee that we'll have time to get to everything, but we'll do our best. So Andrew, do you have anything to add to the Ryder case, to your thoughts on the sort of vacating an order?
Yeah, I mean, just briefly, from an economic perspective, I think there has to be this question for a general purpose technology of bad people are going to do bad things with the technology, and how do you weigh the preventing those bad things with sort of stifling the use of that technology in the first place, or imposing liabilities on the owners and the controllers of that technology in a way that it might stifle that. So I think the contrast perhaps between Ryder and SpyPhone would be, I mean, SpyPhone was marketed kind of right on the tin as, hey, spy on your loved ones. And I think that although there are legitimate purposes for such technologies, it's a little more limited than here's this AI writing tool. And I think that there's a parallel there potentially between the recent X and Grok kerfuffle, where apparently Grok was generating non-consensual intimate photos, and there's been a lot of concern about that, and various regulators looking into that. And the question there is, it's always going to be difficult for somebody who's putting this incredibly powerful tool out there in the world to control all the potential uses. Cars, baseball bats, the telephone, all of these technologies can be used for good things and bad things. How do you, it's a difficult thing for policymakers to do, to try to figure out how to adjust that. So I think that the writer rollback fits in with the general, both, hey, AI looks like it's really important, let's not put too many controls on it ahead of time, as well as a recognition from the economic standpoint of like putting barriers around or guardrails around the use of AI is necessarily going to make it less useful for legitimate purposes as well. And so let's be careful about that.
Right. Well, thanks, Andrew. Sticking with AI, Maneesha, I want to turn back to you and ask, because you would and dig in a little deeper on the Trump executive order on AI and what it has to do, how this is what the FTC's role here, and also the state landscape is so important, and you as a practitioner. How are you counseling clients to navigate this? Because on one hand, we have the administration with the executive order looking to sort of preempt a lot of state regulation. At least that's how I see it. And I'd like to hear your views on that. And then the other time, you have the states being very active. Either through specific AI laws or privacy laws that impact parts of AI. And again, I know there's a lot of action in the states, and so you're counseling, clients, so kind of first, if you can just unpack a little bit what's in the Trump executive order, how that relates to preemption, and then what the role of the FTC is in this. You mentioned it a little bit, but I know the chair is supposed to do some sort of policy statement or something. So anyway, Maneesha, if you can kind of unpack this a little bit for us.
Yeah, sure. So just starting with the practical question, when my clients ask kind of, oh, well, are the state laws going to be preempted? Do we need to worry about the state laws? What I usually typically say is that, the executive order does not have the force of law. The administration is asking agencies to do a bunch of things, but the executive order is not self-executing. There are certain state laws on the books right now. And they are kind of valid, and the states will enforce those. And particularly when we're talking about some of these states, California, Colorado, I don't know that they're going to be cowed by the administration, just this kind of executive order to not enforce their laws. So we are kind of advising clients to pay attention to what's going on at the state level. Now, one of the things in terms of the FTC is that the executive order calls on the FTC to figure out ways to preempt state laws under the FTC Act. And I think that is a bit of a tall order, let's say, because I think, again, just kind of a quick level setting on preemption, the FTC Act does not expressly preempt state laws. So there's three kinds of preemption. There's express preemption. The FTC Act does not expressly preempt state laws. There's field preemption, where Congress intended to occupy the field with a federal regulation like the FTC Act. Well, that doesn't apply here because we see, there's state FTC Acts, there's state laws on consumer protection. FTC works with them. FTC rules contemplate working with states on consumer protection issues. So there's certainly not an intent to occupy the field. So there's no field preemption. So then the only kind of preemption that the FTC could assert would be conflict preemption. And that is where a federal requirement expressly conflicts with the requirement of a state law. Nothing in the FTC Act conflicts with the requirement of a state law, but you could see a situation where the FTC might pass a rule, let's say under Mag-Moss, and then the requirements of the rule would conflict with state law, in which case the FTC could preempt state law. And that's what Lina Khan tried to do with the non-compete rulemaking in the last administration. But I do think that's kind of again, as I said, a tall order. The FTC has been told to be hands-off on AI regulations. So I don't see the FTC enacting a rule for the purpose of conflicting out state laws. So I do think that's kind of unrealistic to think that the FTC is going to preempt state AI laws. And so I think the bottom line here, I mean, there might be some tools that DOJ might have, kind of withholding funding, things like that. But I do think this will be a long drawn out fight. And until then, I think the state laws continue to apply.
Um, a, a quick follow up on that, Maneesha, and then Andrew, I'd like to get you to weigh in. In the executive order, and unfortunately I don't have it right in front of me, but to your issue about conflict print, I think that's interesting. By the way, it took me back to con law. I think some of this is coming back, different types of preemption. Um, Part of the order, or there's language in the order for the FTC to find, to preempt state laws that might require deceptive outputs or inputs into AI, something like that. I confess, I mean, I get it from a conflict preemption. You say, well, the FTC Act says you can't lie, and here you're requiring people to lie. Do you have a kind of an insight as to what they're getting at there?
Um, I only can speculate. I think there's this kind of labeling of certain laws, like let's say the Colorado AI law requires risk assessments for algorithmic bias. And I think there's this kind of let's say like the AI. I think the kind of administration, maybe this is a talking point, or I've seen this in the news in the press, that like if the AI says there has to be a black George Washington, that could be a deceptive practice. As a practical matter, as a matter of reality, none of the state laws require anything like that, as far as I can see. But that might be what they're getting at. If the requirement is to have some sort of like non-discriminatory output, that could be deceptive. But again, I don't see that as a viable theory under the state laws.
Okay, interesting, because I had maybe this is a different webinar, a deeper discussion about this, because it also seems, and again, this is just an aside to sort of dovetail in at least the current administration's potentially dovetail kind of fight against DEI and
Yeah.
that this would be an area. But again, unfortunately, perhaps the topic for another webinar on this. Andrew. I'm not going to ask you about the law of preemption. I guess I don't remember getting that in my PhD program. I had to actually come to law school for that. But what I did want to ask you from an economic standpoint, and again, from someone who's actually working with clients as well and thinking about this, is on one side you have all this sort of patchwork of state doing privacy/AI, and then you have this executive order to say, no, we need to make this kind of a national policy. Do you have any, really putting your economics hat on, any view on, the states as laboratories of experimentation versus, we need to have kind of one AI policy, and this patchwork is just going to be bad for business?
Yeah. So first of all, I love federalism from a sort of general sandbox laboratory standpoint. So when I was at the FDA, before I was the FTC, I worked on the calorie labeling rule for restaurants. And I loved the fact that not necessarily, I didn't want to necessarily live in these jurisdictions or not, but like New York and Seattle and all these different jurisdictions were trying these things out. And so we would have these great natural experiments of, hey, some locality wants their restaurants to label calories. How does that affect consumers? Does it affect consumers? And just from a sort of scientific standpoint, fantastic, right? Because we get to try these things out and potentially at a lower cost than rolling something out nationally. The problem with digital policy being state-based and even country-based, frankly, is that if you have a product that can be accessed anywhere in any state or in any country, you're kind of on the hook no matter where you are for those local rules. And as we saw with some of the GDPR regulations and CCPA, bigger firms with bigger footprints are going to be saying, looking at the various risks and looking at the various costs of approaching this sort of patchwork compliance, and simply saying, you know what, let's just have a fairly uniform approach. It's cheaper. It lowers our risk. We don't have to determine where somebody is or what the rules are in all these jurisdictions. So what that means is that for the AI, for the big AI players, they're really going to be ratcheting up their compliance costs by having to deal with all these different jurisdictions. So I think it is a bad idea to allow this patchwork approach in the US, because it is going to create some real difficulties for firms to comply with that. I think we've seen at least some rhetoric, especially around the Colorado both privacy rules and in particular the AI rules, where as soon as it was passed, businesses in Colorado were like, "What are you doing? We're leaving because we can't comply with this and actually do business." And there was immediate like, "Oh, no, we're going to roll it back." I don't think they've successfully done that yet. But that's the problem, is that you have these wide-ranging tools and you've got users all over the place. You're going to have to potentially have 50 different compliance regimes, or simply say whatever the tightest one is, we will comply with that. So, on one hand, you say, well, federalism's great. You get states to determine what their citizens want. On the other hand, states like California may be de facto imposing their preferences for these tools across the country, because it's just not efficient to customize that from the firm standpoint.
Well, thanks, Andrew. I want to pivot now to something we talked about a little earlier, and stick with you, Andrew, because this is the first part of this question is an economics one, and I want to go back and talk a little bit about surveillance pricing. And the reason I bring this up is it's kind of not necessarily at the FTC, but it's kind of become a hot topic in the media, with certainly with affordability being the main political watchword these days. There have been some highly publicized studies. I mean, they've gotten press in some major newspapers, and I'll put studies in quote only because, I mean, they're sciencey, but they wouldn't necessarily pass muster at the Law and Econ workshop here, though I invite any of them to come and present. But there's one study in particular that shows that a major online delivery platform ends up charging slightly different prices to different people for the same basket. There's another study that's co-authored by the former director of the Bureau of Consumer Protection, now working in New York City, that talks about online loyalty programs. That data from that is used to kind of screw over consumers. And there's some problems with the study, lumping in Starbucks and Harris Teeter programs with high cost travel reward credit cards and Amazon Prime, and then the FTC case against FleetCor. I don't know what those have in common, but leaving sort of the methodological flaws, which would be another thing I'd love to talk about. The upshot is that, again, in this political era, these studies are kind of seem to be driving state and federal laws. The idea that the surveillance pricing, there's one in New York that I think requires disclosure. I don't know if, and then Maryland, apparently, the governor of Maryland recently announced a law to prohibit grocery stores from engaging in kind of surveillance pricing. In Congress, something was introduced not that long ago called the One Fair Price Law, and they referenced some of these studies. And then, there was a report from Reuters that FTC was actually investigating Instacart for differential pricing based on some of these studies. So, first, I want to ask you, as an economist from a policy perspective, again, taking off, I know, whether you have clients on one side or another of this, but, what do you think of this sort of pricing? And one thing is I want to, there's surveillance pricing, and maybe if you can unpack the difference, between so-called individual surveillance pricing versus, say, random assignment pricing, where you're trying to discover a demand curve, versus dynamic pricing, which is about aggregate supply and demand. I think often those get lumped in together, but they're quite different and maybe have quite different welfare effects. So if you want to tackle that, Andrew, then I'd like to turn to Maneesha when you're done, and talk about the law, possible legal hooks here.
Sure. So let me start off by saying consumers hate personalized pricing. That is like, regardless of the economics or anything behind it, people just don't like it. And just like they don't like their insurance to be tied to their terrible driving, they don't want their grape prices to be tied to how desperately they want a grape. So I think that's what's driving a lot of the interest here, is that just people don't like it. They think it's unfair. And that seems to be true even if they think they're going to benefit from it. There's some studies that suggest that people who know they're going to benefit are still like, well, it's unfair, it shouldn't happen. So, there's that issue here, like there is, for example, in some of the no bots ticket rule, where there's an efficient allocation, and the economics of it suggests that you should just let the market work, but consumers hate that, and so they want to pass a law. In terms of some of the differences here, so there's dynamic pricing, which is not based on the individual, it's based on sort of known patterns of supply and demand. So Friday night, when the bars close, there's going to be a surge of interest for rideshare drivers, as well as a lot of rideshare drivers who want to go home and go to bed. And so that potential disconnect between supply and demand is going to say, hey, if you're a rideshare driver and you come out and make yourself available, we'll give you a little bit more. And by the way, demand has risen as well. If you want to ride, you're going to pay for it. Anybody who's flown into National Airport at 8 o'clock on a Sunday night knows what I'm talking about. So that kind of stuff, consumers are also a little bit unhappy about, though less so than personalized pricing. There was an experiment 20 years ago where I think one of the soda companies put out some soda machines that were responsive to temperature. So the higher the temperature got, the more the price of the Coke got up. People hated that. Could have been apocryphal, but that was the story that was going around. In addition, firms do, especially if they're online, and so it's relatively cheap for them to adjust prices, they do run experiments all the time. They want to know what the market will bear, what the price is that maximizes their profit. And so they may offer up some randomized pricing, again, not based on people's demographics or their information, but just here's a bunch of random prices. What are people willing to pay? And that helps us, as you say, construct a demand curve. The thing that people respond most negatively to is somehow their individual information is being captured in a way that influences what they pay. And the thing that they're sort of most unhappy about there is that somehow the data that's being collected is going to secretly figure out, what your valuation is for a cup of coffee. So you walk into the coffee house, they scan your retina, they hand you a drink, they know what you want, and they simply just debit your card because, of course, we know what you're going to pay for this. And you walk out and, you have your cup of coffee, right? But people imagine that all that's going to happen is you're just going to get all that surplus pulled out of you. The research suggests, and this is the last thing I'll say, is the research suggests that depends on the market. It turns out competition matters. And you can imagine yourself at a car dealership, you're negotiating for a car and they're really putting the screws to you. You've been there for 3 hours, you're getting really tired, you're about to give up, and then your phone dings, you look down and the dealership across the street is like, hey, I see you're looking for a car. We'll give it to you for $1,000 less than what that person wants to offer you. Sounds kind of good, right? So the question is, what kind of competition is going to arise from a world where everybody can offer you a personalized price? And the research suggests that for more mass market goods, where sort of everybody values things similarly, cup of coffee, you're actually going to see benefits. So the majority of customers are actually going to benefit from an increased competition, even though customers sort of at the high end of the market might end up paying more, their surplus goes down, but you're expanding the market. The opposite of that would be for really niche products where there's not very many suppliers, not very many consumers, you're going to get soaked potentially. So it depends.
I like how you ended with the normal economist thing. It depends after that long. But I think your point about competition, kind of this idea of price discrimination, extracting surpluses based on the very rudimentary idea of monopoly price discrimination, and you forget that almost always price discrimination exists in a competitive environment, some type of competition, and if all the parties in that market have the ability to target, you can actually end up with lower prices for everyone. I mean, it depends. There's theoretical work out there, depends on best response asymmetry and things like that. Again, another webinar. We've already put a pin in like 4 different webinars we need to have. But I know we're getting close on time. So Maneesha, I just wanted to ask you, I mean, we heard a little bit about the economics of it. As someone, again, a former FTC enforcer, someone who currently counsels clients, is this something, from a legal standpoint, whether it's a state law, whether it's these new laws that are going to affect, whether it's the FTC Act, that you think is potentially something firms should worry about if they're considering offering differential prices or targeting discounts to different groups?
Yeah, so just from an FTC Act perspective, I don't see the hook that the FTC would have unless somebody has made a statement suggesting that they don't do differential pricing or that they will charge X price. So I think the FTC hook would be if somebody, like, I guess they could say that you failed to disclose that you're engaged in dynamic pricing, but you'd have to show that that was material to consumers. And then under unfairness, the FTC would have to prove that there's been harm to consumers, and I guess the consumer that's been charged a higher price could allege that there's harm to them that's not reasonably avoidable by consumers. If there's a disclosure, or if there's competition, it's probably reasonably avoidable. And 3, that the harm to that individual consumer is not outweighed by benefits to consumers or competition. So I think that any firm that engages in dynamic pricing or kind of differential pricing would have to have the economics to show that this is overall beneficial to consumers. So I think that it's tough to find a legal hook under the FTC Act. I know that states are turning their attention to this issue. So New York passed a first of its kind surveillance pricing law last year, but then that was immediately challenged by the Retail Industry Leaders Association. I believe that's enjoined, but I haven't checked lately. But I do think that we're seeing a lot of state enforcers that are showing interest in this issue, again, as part of the kind of pocketbook issues that affect consumers. And as Andrew said, consumers hate it. So I remember when 66, for those in Arlington, 66, started charging tolls based on kind of the traffic. And I remember that when it first came out, the toll was $47 to get into DC from Arlington, and people were outraged. So I think that's goes to Andrew's point about people just don't like it. And so I can see states getting into the mix on this issue.
Okay. Well, thanks. To be continued. Certainly affordability, an issue, and we'll see where this is. And again, this will be our next webinar. We'll have many of these. In the little bit of time we have left, since I have again 2 former FTC colleagues with me, this isn't really necessarily about privacy, but I'd like to turn maybe to a bigger picture and talk about what's going on, with Humphrey's Executor, something that I've occasionally taught before. I never in my life would have thought Humphrey's Executor would be a New York Times front page story, a case about a dead commissioner's estate trying to collect the pension, right? This pension. But the Supreme Court will decide, I guess, by the end of June, the Slaughter versus Trump case, which is the ability of the executive branch to fire without cause commissioners. Now, what we see right now at the FTC is we see a 2-0. We see 2 Republicans and nobody else, and soon we'll have I don't know if soon, I understand another person has either officially been nominated or maybe nominated soon. So we'll have a 3-0 commission again, with no indication that we're gonna get someone else, and especially if the Supreme Court experts seem to all predict that the court is likely to rule against Slaughter and overrule Humphrey's Executor, whether how broad or how narrow, but nonetheless we'll probably be stuck with the status quo. So what do you think this how do you guys feel about this? What do you think the impact will have at the commission? I know as a staffer myself, and I was there when it was kind of the normal 3-2, we would unanimity was prized. I mean, you would try very hard, regardless of who was in the leadership, to get either both of the Republicans on board if it was a Democratic commission, or both of the Democrats on board if it was a Republican commission. And so, that, and there, I'd be interested to get your perspectives on whether you think, this is how this is likely to change the FTC going forward. So Maneesha, I'll let you have the first word on this, and then Andrew, I'll let you close us out. We have about 4 minutes left for this for this.
Yeah. So I think that it's I think you're right that the Supreme Court will probably not reinstate Commissioner Slaughter, and that this will continue to be a 2-0, 3-0 single party commission, which I think is unfortunate because the reason you mentioned, I think the kind of striving for unanimity kind of helps get to the I think better policy outcomes. This is my personal view from having been a staffer there. I also think the lack of public dissent I think it creates less transparency for kind of the debates that are going on inside the building. So I think that's probably unfortunate. And I think there's more of a swinging of the pendulum, every 4 years or every 8 years, back and forth, which I also think is unfortunate. I think it's unfortunate for the staff who works there that have worked really hard on something only to be kind of disbanded 4 years later. It's bad for businesses who have less certainty. I think there was a question in the Q&A about DEI issues and the kind of the discontinuity between administrations on kind of protection of certain populations. And so, not only kind of does that swing in public policy kind of affect consumers, but it also affects businesses who are trying to follow what they're supposed to do. And I think it creates just unfortunate effects.
Well, thanks, Maneesha. Andrew, what are your thoughts on reading the tea leaves if the FTC turns into just sort of a normal executive branch agency where commissioners can be fired without cause just because they disagree with the president's policies?
So I've worked both for an executive department, FDA, and for the FTC. And frankly, I understand the value of both of those approaches. There were pluses and minuses to working in sort of the unitary leadership model at the FDA, and there were a lot of things I liked about working at the FTC, not least because it gave me a voice as often, not that often, but with some regularity, being able to say, I don't think this is right. That said, when I was at FDA, I would often say I disagree. It's sort of how it plays out is a little bit different. I would certainly echo some of the concerns that Maneesha raised, just of the disruption. Like, let's figure this out. I think many of us that worked at the FTC really valued the way that it ran and saw that as quite valuable. Ultimately, let's figure out where we're going, get some stability, and move forward.
All right. Well, I think we are right up at time. And we've done a good job at trying to answer some of the questions in the queue. I apologize if we haven't been able to get to everyone. But Maneesha and Andrew, I want to thank you both so much for your time, and put in your calendars for this time next year. We'll do it again. But this has been a great conversation. I could keep going, and I've learned a lot, and I'm sure that our audience has as well. So again, thank both of you. I want to thank both of you a lot for your time and your insight today.
Thanks, James.
Thanks, James. This has been great.
Okay. Well, thank you, and that's the conclusion of our program.